You're watching Single Process with Joe and Bob. We've created this video series to help you navigate through the difficult process of divorce. Our topic this episode is on home and finances during the divorce process while you're separated. Bob, this was a tough one for me.
This is a huge one. I've heard the stories about people actually hiding cash under their mattresses because they're worried about having access to bank accounts.
Well, I just couldn't imagine carrying on living together while we were negotiating this divorce.
Totally.
But I didn't want to leave, he didn't want to leave, I didn't know what to do.
And what happens if you leave? Have you then legally abandoned your right to the home? So I mean, all those questions are really vital.
I still don't know the answer to any of them, having gone through the process, which is why we are addressing this.
Yes.
And we're excited to have Carole Orland here today.
Yeah, Carole Orland is a founding member and partner at Broder and Orland, which is a law firm in Connecticut. And she has been practicing family and matrimonial law for over 30 years. You won't know it to look at her. She's consistently recognized among the top 10 attorneys in family law in Connecticut, among many other distinctions. So, Carole, thank you for being with us.
Thank you very much. I'm delighted to be here.
Start out with a separation agreement. You decide you're getting divorced. During the interim process, should you have some kind of separation agreement?
Sometimes yes, sometimes no. So sometimes the parties, even though they're getting divorced and there might be some acrimony or some tension between them, can really decide how they want to live during the separation process. And you can just sort of have verbal understandings as to how you want to continue to pay your bills or how you want to continue to see your children, and you don't really necessarily need to have a written agreement. On the other hand, sometimes you do. So if the parties can't agree, you can go to court. Either party can go to court or both parties can go to court and file a motion, let's say, for alimony or for child support or for parenting time.
So, Carole, you can actually get alimony during the course of your separation?
Yes, you can. It's called alimony pendente lite, which is a nice Latin term for during the pendency of the case, right? Go back to
So
Latin.
who would be likely to do something like that? If you feel like your spouse is going to hide money or not be upfront about things or give you access to bank accounts?
Well, the latter maybe. Not if you don't have access to bank accounts, or if your spouse, let's say, agrees that you will have some access but it's not enough, or your spouse had been previously depositing, we'll use his, I don't want to be sexist about this, his paycheck into the bank account, and he's no longer doing that, then you're going to need to go to court to make sure you can get access to those funds, or to get an alimony award order.
I've heard these stories about women who are afraid that they're not going to have access to money. Actually, again, I said women, I don't mean that, but they'll hide cash under their mattresses to make sure they've got money to pay attorneys and other things. I mean, you're saying you don't really need to do that. You have...
Well, I don't really want to know about hiding the cash under the mattresses. And the
These
good
are
thing
just
is...
friends in our imagination, Carole.
We have really high quality friends.
We are legitimate and above board, so I don't want to know about that. But I will tell you that as soon as the divorce complaint is signed and as soon as it's served upon the other party, the automatic orders go into effect. And they're orders that are supposed to prevent any sort of financial shenanigans, people buying things or moving things or transferring assets. It's really supposed to continue, as I say, business as usual.
Okay.
Now, the good news is, although that precludes a party from going out and making an expenditure that he or she hadn't made before, anything that's substantial, attorney's fees are accepted out of that.
So you can
Isn't that amazing?
Good for the
you
attorneys.
can rack it up, but you're entitled to access funds and pay your attorney during the process. And that's not a violation of the automatic orders.
So what happens to other liabilities? I just want to back up 1 second. If I go out and I decide, you know what, I'm not going to, everything's 50 cents on the dollar right now until we get divorced.
You want to get a boob job before the divorce is done.
And that happens, let me tell you. And so sometimes our clients on their financial affidavits, we have a big line there for plastic surgery. You'd be surprised.
Seriously?
And honestly, if our clients are regularly getting plastic surgery, or even if they're not, and they've had an expenditure or they anticipate an expenditure, we're going to put that on the financial affidavit.
Wow.
It's not uncommon around here. It really isn't. That's a usual expenditure for me, right? But to answer your question, if it's something that he or she hasn't done before, and now the divorce has been filed, and it's like, all right, I want to go get, my eyes lifted, or I want a face job, or as you said, I want to be a little careful there. You need to be careful about that.
So it's business as usual. The minute the divorce is filed in court, the clock starts ticking.
That's pretty much the way it goes.
Okay.
Yeah.
That's the guideline.
The safe guideline. Okay. Okay, and you were talking about the family home.
I want to talk about the family home. I think that presents a problem for so many people. Yeah. Everyone wants to hold their ground, but no one wants to actually continue living together.
Yeah.
So well, of course, you've already announced to everybody, including your kids, that you're moving on.
It's a huge issue, and unfortunately, in most cases, both parties end up staying in the marital home while the divorce is pending. Why? Sometimes it's because he or she wants to hold his ground. There's no abandonment. If you were to leave the marital home, you're not abandoning it. You're not forfeiting
giving up
it.
anything.
However, it would be rare to see a party leave the marital home who really wants to have the marital home at the end of the divorce. So that usually doesn't happen. What happens frequently is parties will live in separate parts of the marital home. Sometimes if there's an order, let's say for exclusive possession, you go to court. Sometimes the court even orders the parties to live on separate floors in the marital home. We have all sorts of rules. We have locks on the doors. We have signs. We have all sorts of rules as to where people can go in the house at a certain time. That gets really carried away. Again, hopefully...
This sounds like the War of the Roses. Do you remember that, where they split the house in two?
Totally. So, look, either party during the divorce can move out and get his or her own place. And usually during the divorce, the children will stay in the marital home.
I was just about to say, as there's alimony patente lite, is there custody arrangements or orders of court during the process of divorce if somebody does move out?
Well, very early on, the court requires the parties to file a parenting plan. And it's a parenting plan that, again, has to be adopted at the end. So sometimes it's the same when you get divorced, but sometimes it's not, because it's so early on, and sometimes the parties are living together, that the arrangements are going to be different once they get divorced. But the court, children come first in everything we do. And in our firm, it's so important to us that the children's issues are taken care of up front. So that really should be the focus at the beginning of the case. Okay. How are we going to parent our children? And again, most people, even though they're going through divorce, are able to arrange something that makes sense for them and the children.
Right.
Look, what are you going to do? If you have, let's say, we'll be sexist here. Well, let's turn around. Let's say you have a woman who's working on Wall Street, and she's on the 6 o'clock train, and she's coming back at night at 11 o'clock at night. To say that she's going to have parenting time with the children 3 days a week after school is unrealistic, right?
Yeah, right?
So she's going to, if the husband, let's say, is more local, she's going to want her parenting time to be more on a weekend, to have more holiday time, to have more vacation time. Usually the schedule is what dictates what the parenting time will be. Even though in the beginning so many people say, I want 50-50 time, and we're like, really? How are you going to work that out? And it's like,
I always assume, Carole, that you don't hammer out an agreement until you finalize the divorce. This is all news to me, that you really need an agreement during this interim period.
You can reach certain agreements during the interim period. You have to agree on some sort of parenting. You can agree on finances. You can agree sometimes you have to get a guardian ad litem involved for the children, or an attorney for the minor children. You can agree or not agree on that. Sometimes the court will order that. There's all sorts of agreements. I mean, essentially, I suppose you could agree on anything during the course of the divorce. If the parties want to do that and you have a written stipulation, the wise thing is to have it in writing, go to court, have the court order it, because then if one party doesn't live up to the agreement, you have an action for
contempt or to compel. Does it take a while to get into court? It takes a while to get a court date.
It depends on what you're looking to do. Yes, anytime you file a motion, it'll take at least a few weeks to get into court. The trick isn't getting into court the first time. The trick is getting the court to hear your case, because many of the court dockets are overloaded, and you get in on what's called the short calendar day, which is when you initially try to get in for your motions, and it's crowded, it's busy, it's full to the gills, and sometimes you don't get heard, and you have to come back and come back.
And that's
come
another day
back.
of work and
So
another day of
the
work.
smart thing to do is really try to agree between yourselves. That's
Okay.
always best than getting into court. And court is time, and time is money. So
Absolutely.
sometimes that's unnecessary.
I want to follow up on one more question back to the living together. Let's say you are both in the house and you're just finding it completely untenable. You just cannot think, and you think it's not in the
I
kids'
think
best
that's
interest.
highly likely. I would be surprised if most people live in harmony during this period.
Well, I don't say they live in harmony,
but they're
have some
forced to
sort
make
of
it work.
a tacit understanding or a détente, maybe. But
Right,
yeah,
but
sure.
my question is, if there's something going on, what would ever give you the right to force a spouse out of the marital home?
That's a great question. It's very difficult to get exclusive occupancy. That's the term for having one spouse stay in the house and the other leaving the house. Usually it's in cases where there's abuse. Usually physical abuse is sort of the preeminent issue for getting somebody out of the house. Sometimes if you can show the court that it's such a toxic environment, particularly for the children, and that they're suffering, and there's something really that you can articulate tied into that, sometimes you'll have a chance of getting the spouse up, but it's very, very
It's the
difficult.
exception. It's rare.
It's very difficult.
So there's no. You may as well try and make it work
Well,
to the best of your ability. Right. I mean, if there isn't.
Go in and you get it done. I mean, it's terrible to live in that situation, particularly for the children. So it varies from situation to situation.
Should you start breaking up bank accounts and things like that interim?
No, you don't break them up. In Connecticut, we're an all property state. So that means at the time of the divorce, no matter how any account is titled or asset is titled, it's all marital property. We're also not a community property state, so it's not that each party gets 50-50 per se. The court looks at a whole host of statutory factors in deciding how to allocate assets at the time of the divorce, no matter how it's titled. They may move your IRA over to your husband. They may take a joint bank account and give it all to you. So moving the accounts isn't something that's really going to
No
change
benefit
the
in that.
outcome.
No, unfortunately. I was going to pipe some money over to the Caymans. Right on, Carole, right on.
Well, we actually are thinking about an office in the Caymans.
I'd like to be a client there.
Well, Westport, Greenwich, Caymans, it all fits in.
That's it.
Thank you. Well, thank you, Carole, for being with us. I mean, really helpful stuff, because I think a lot of people are confused on where to go in that interim period. So for information on this segment and more, please check out our website at singleprocess.me.
Thank you, Carole.
Thank you so much.